Right, you are welcome to today's class. I welcome you all, and I believe that all that we are going to do today is going to be a good and excellent result. So you are all welcome. We have so many things to do, and part of what we are going to do is that in this revision class for November 2018, we are going to be looking at a method or some points that we need to know about answering examination questions generally, and also we have some points to note on answering business law questions. And so then after that, we now go into some of the past questions. So, and then we are going to look at the questions and also how to answer those questions. There are some terms being used, to ask questions, which we are going to elaborate, and we are going to explain. All right, so the first thing we want to see here is this answering examination question. And I have number one, the first instruction is read all instruction. So whenever you are in the examination hall and you want to start anything, the first thing you need to do is to read all instructions. So where you have the question paper and then you want to do anything, so before you do anything at all, ensure that you go through all instructions. So reading instruction is very, very important. Read the instruction well and ensure that you understand all instruction, and you have to follow the instruction. Don't do anything without first reading all instructions. So because where you just begins to answer your question and you don't read the instruction, then there's no how that you will not make a mistake. So that is the first thing I would like to pass across to you. And also number two is that go through all the questions. So after reading the instruction, then you go through all the questions. So go through the questions, check the questions, so that in the process of checking through the question, it is then that you'll be able to decide the ones you are to answer. So you have to go through it so that you know the one you want to do. So go through the questions. That is the first thing. The second thing you need to do. Then number 3 point is that write down any point that comes to you for each question as you go through. So that means as you are going through the questions, so you begin to, when you check any question, whatever that comes to your mind, jot it down, so that by the time you want to answer that question, you don't forget. So sometimes when people are going through questions, they may have points, they may have some answers to a particular question, and then by the time they now decide to handle that question, they may not remember what came to their mind before. So that is why when you are going through questions, ensure that you are writing down or jotting down anything or any answer or solution or any point that comes to your mind, you jot it down. So you jot it down. And also number 4, mark the question you want to attempt. So after that, you now mark those questions you want to attempt. So maybe we have in the section maybe about 5 questions or 6 questions, and you are asked to answer 3 questions. So you mark those ones that you want to attempt. So, and when you ensure that the one you want to attempt, of course, are the ones, or those ones you want to attempt are the ones you actually know best. So please ensure that you mark as you are going through. Then the fifth point is that start with the question that is easier for you to solve. So when you are going through it, you ensure that you start with a question that is so easy for you to solve. So that is what you need to do. So you look all the questions, you mark them down based on how the questions appear so easy for you to answer. So it is very good to answer with a question you know best or you can answer well. So start with that so that you can uh, you know use your knowledge and the energy you have on that very question. And also the sixth point is that allocate time for each question you want to answer. So you have to allocate time. So you have a time schedule, okay, for the paper that you are answering. So if it is 3 hours and you have to answer 4 or 5 questions, so you now ensure that you divide the time given to you for each of the questions. So allocate time. Time management is very, very important. So you don't, when you time yourself, so that is where what will help you to answer. If you have to answer 4 questions, that is what will help you to attempt all the 4 questions. But if you don't have good time management, you may use more than half. If you want to answer 5 questions, you can use more than half of the time given to you for all the questions to answer 2 questions, and that will not be good enough. So because maybe you want to do justice to the one you know very well, and you keep on writing writing. So before you know it, you will discover that the time left may not be enough for you to answer the other questions. So that is why time management is very, very important. Where you allocate time for a particular question, and then ensure that you are looking at the time and you are answering the question. Ensure that you avoid writing things that are not necessary. Write necessary things. So write things that will give you mark. So you write that before you now go to another question. So these are the general information I want to give to you concerning answering examination questions. So follow this. So time management, as I said earlier on, is very, very important. Now let's also look at answering business law questions. So business law, is having its own technique. So business law is quite different from other courses, because it is discovered that people who are doing business law, especially at this very level, are those who are not familiar with law before. So business law is different from economics, is different from other things that you may want to do, which actually maybe some of them you have gone through maybe through all this at your university days. But when you are talking about business law, is quite different, that some people don't really know about it before. So that is why you really need to listen to this information. The first thing I would like to say under this is refer to true and known cases alone if there is need. So where a question is set, or where you want to answer a question and you discover that you have to mention a case or cases, ensure that you mention cases that is true, existing cases. You don't formulate case on your own. Don't just think that you can just write anything, because those who are examiners are also, or those who are to mark your papers, are those who are also familiar with cases. Okay, so they are learning people. So if you formulate your own case that is not a true one, that is not actually existing, they will know. So ensure that if you don't remember any case, there is no need. It's not compulsory for you to cite or to explain any case. So, but where you can remember, cite it down, then write the case down. That is the story. So the fact of the case, you put it down. But if you cannot remember, there is no need. So don't just try to form anything on your own. That is if need be that you want to cite cases. Then 2, quoting status is not compulsory. Yes. So if you are answering questions and the question you want to answer, there is, you maybe is referring to a particular provision of the Constitution, or is referring to a particular provision of the law, then you can cite it, but it's not compulsory. Citing cases means that when you are referring to where the law is or enshrined in the Constitution, or whether in the criminal code, okay, so it's, or whether in EFCC code, it's just like when you are seeing section 2 or section 5 of this criminal code, or EFCC Act or ICPC Act. So that is citation. So, but it's not really necessary for you to cite if you cannot remember. So it's not compulsory. So sometimes you refer to laws. Okay, when you are writing, you should understand that you are not a law student. So that is why it's not really necessary. You can refer to the point of law, or you can refer to any particular law or status. So if you can remember where the status is from, that is the citation, you put it. If you can remember, if you cannot, then there is no need to do that. Okay. Yeah, take for example, if you are quoting something from the Nigerian Constitution, you can just say, based on the provision of the Constitution, that there is a freedom for this and that. That is, there is a we have in our Nigerian Constitution freedom of movement, freedom of association. You can begin to say that, but where that very law of ours, so it's enshrined in the Constitution. If you don't remember, there is no need for you to say or to cite anything. Just make mention of the provision. And also, the number 3, read case application question at least 2 times before you answer the question or give any advice. So when you want to answer case application question, we have case application questions where somebody the examiner will ask you that we bring out a scenario. Okay, that is the case application, and then we now tell you that what is the position of the law, or what is your advice. So where you have case application question like that, and then a scenario is portrayed, so please ensure that you read at least 2 times. So I will advise you nothing less than 3 times. Read this, and read it again, so that you'll be able to understand. Case application question is something that you need to take seriously, because if you don't read it very well, you may not really get it. So it's not just a story that you just hear or you read halfway. It's not a story that you just quickly glance through, okay, and you are able to bring 1 or 2 facts out of it. No. So okay, when you have a case scenario, you have to read it well to really begin to point out salient issues. Okay, there are some things that you may not, if you just read it, so very fast, you may not be able to pick out some certain points in the scenario. So that is why it is good for you to cool down whenever you are reading any scenario. In order to answer case application question, you look at it well, you read it again, cool down, and read 2 times, 3 times, even 4 times. Read it very well to really know the strong point, to really know the weak point in that very scenario. It is very, very essential. And also, of course, you have to do this based on the time given to you. And also, question number, let's look at number 4. Follow right steps to answer case application question. In answering case application question, we have steps. So we have steps, which maybe as we go into the past questions, I will also be able to explain what I mean by the steps. When you are answering, but let me quickly say this here. When you are answering case application question, you have to examine about 3 steps. Okay, you have to make mention of the origin of the question. So if a case is analyzed, and then you are now asked whether to advise, so or to say something, or state the position of the law, you have to, that very scenario created, you have to be able to tell the examiner where that case originated from the topic that you have treated in the under business law. So that very case must be from a particular topic. That's what I'm trying to say. Must be from a particular topic. So you can now say that this very case relates to maybe misinterpretation, or maybe battery, maybe relate to breach of contract. So then when you now say that, then what the principle in that very case scenario or the topic, the principle in the topic, that's the second step, you state it. Then after that, you now give whatever advice you are asked to give. So that's why I said it's in 3 stages. So the origin of the question or the case, and also the principle guiding that very issue, and also you now give your own advice. Let's also look at number 5. It says cite cases with capital letter. Okay, so whenever you want to cite any case, it's good to cite the case with capital letter. And whatever you want to say concerning the case, then you can use a normal way of writing. Starting case with capital letter is what I've given here. Adewumi versus Soshino, for example. So that has to do with a capital letter, so that the case, the examiner will see the citation. So then you now explain, you mention the fact of the case. So answer it or start it with citation means where the case is from. So you now explain there are all the parties involved. So that is, you cite it with a capital letter. So these are the point I want to mention where it has to do with answering business law question, and also where you have objective and then you want to pick. Also ensure that you read very well before you pick whether it is A, whether it is B, whether it is C, D, or E. Sometimes where a question is asked, you can see maybe in the middle of the question, maybe not. So that is why when you are reading any question, you have to look at it very well. Sometimes the question may be, which of the following is not a feature of our Nigerian Constitution? It's not. So if you just read it, you take note of every word mentioned or written, so before you can then proceed to answer the question. So if you don't take note of all this, then there is a possibility for you to make a mistake. So that is these are the instructions I want to pass across to you. And let's look at the past questions. And this past question has to do with May 2018. So we have instruction here. That's why I said whenever you want to answer anything, you have to first listen and then read the instruction very well. And then so these are the questions. So we have these questions in this section, in this very section, and is about 20. Let's look at it. All right, so we have about 20 questions here. That's under section A. So, but when you look at section B, you have about 6 questions. So that is section B. We have 6 questions and you are asked to answer 4. So that means that you are asked to answer any 4 questions. So any 4 questions, so you choose the one you actually want. So what we want to do here is especially I want to really focus on this. I want to focus on this very section, that is section B. If you look at these questions, it's talking about that is question 1. And that question 1, A aspect of it says, say 3 type of received English law. Where a question is like this, so this is actually what information I want to pass across to you, so that you'll be able to get or know how to answer question properly. Say 3 types of received English law. Type of received English law, you see state. So that means that when you have seen something like this, state, just what it means that you have to mention. There is no need for you to explain anything. So all you need to do is to mention. So sorry for the break. And also so when it's, as I've said before, when you see something like state, what it really means is that you should actually mention. And also question B also mentions state. So it says state the parties to criminal proceeding and civil proceeding. So all this type of questions don't need much. What I'm trying to say is that you don't just waste time on this type of question. All you need to do is just to mention, so that you proceed. And also, if you look at question number, the second aspect, the B aspect of it, it says required. So that means that what you have to answer under this. So it's talking about misrepresentation. It said, what is misrepresentation in contract? And also it says state 2 types of misrepresentation. All you need to do is say state. I say, what is misrepresentation? So it's a question. So you have to define what it means by misrepresentation, not elaborate explanation, but you go straight forward to what it means by misrepresentation. And then it says state 2 types of misrepresentation. So when the question is state, that means that what you need to do is just to mention and nothing more. Just mention the type of misrepresentation, whether innocent misrepresentation, fraudulent misrepresentation, or negligent misrepresentation. Now let's look at this. This has to do with where you are asked to state the position of the law. So we are talking about C aspect of it. It said Kofi bought a mobile phone from Ajua. So when you read, what I'm just trying to say, that when you read that this type of question, C aspect, the C aspect is talking about position of an offense in this place. So when you read something like this, and then you are asked to apply. So it's talking about application, especially in the area of criminal matter. So when you see something like this, so what you are asked to do is to use what the statement here, and then you apply all the statement to the three, and then state the position of the law. And also we have the aspect. It said there are three conditions under which agency of necessity may arise. And I'll say require state two of the condition. So we have state two of the condition. This one also says state. And when you see anything like state, so what it actually means is that you should mention. So that is state. So agency of necessity, how it can come up, how it can arise. So you need to state it. So you just mention it. So that's why this type of question, there is no need for you to waste time. And also when you look at this number 2, it's talking about share of a public company. And that's a step 4 reason for which a company may refuse to register share transfer. So this one also has to do with state. And when something has to do with state, all you need to do, as I've been saying, is to mention. So there is need not you don't need to explain when you see the question that says state. Then question number the B aspect. Let us check the question. It has to do with a case scenario, but this type of case scenario, let's look at what it's asking us to do. Okay, it's talking about the issue of a partnership. So this one is not actually saying that you should advise. So in this very place, all that you need to do is to read the case. Then you now use what you understand or the scenario, and you now use what you understand about the scenario to answer this very question. So this has to do with 1, 2, and 3. And also when you look at C, it says state the implication of the following contract of insurance. This one has to do with the contract of insurance, and it's saying that the implication, that means that what who is liable. So that means that what you understand before you can answer this question, you actually need to know the procedure of or the process of being an insured person. So that means that a process of entering into a contract with an insurance company, what is involved. Okay, the agent of the insurance company, what is the position of any agent to an insurance company, the position of insurance company, and the position of the proposed insured. So that is what you need to do to answer this. So this question is only trying to ask you what is the position of the insurance agent, what is the position of the insurance company, and at what stage will an insurance company be liable to the proposed insured. So it has to do, as I say, with having a good understanding of insurance, the topic. So let's look at also question number 3. So this question 3 says there are various tests of determining if a company is insolvent. So and I say list and explain. So this one has to do with list and explain. So that means that you have to mention and you have to explain. It's not just saying state. 3 of these tests specified by Company and Allied Matters Act. So it's saying to determine whether a company is insolvent, what are the factors or what are the things that can be seen, or what are the things that we actually manifest to really determine that a company is insolvent. So it now says state and explain. So where somebody sees state and explain, so it means that you have to state and then you have to explain, and the explanation must not be too wide. It must be very short. You only state and you explain briefly. Then look at each aspect of it. Say company indebtedness could be by way of a debenture. Requires state three type of a debenture. So this one is saying state this type of debenture. So it's just state. So what you need to do is to mention the type of a debenture that we have. The C aspect of it also talk about a little case, but it also is saying advice. Saying advice in this place. And where it has to do with advice, as I've said before, when you read the case like this one now, this is a very small this thing is a very small case scenario. So you just have to read and read very well. You say advice Ade PSC. So Ade PSC employed A as a company secretary. A hired luxury car from B enterprises, giving the impression that they were to be used by Ades PLC, but he used the car for his own purpose. So B Enterprise has sued Ades PLC, advised Ades PLC. So now, in answering this question, as I've said before, when I was given instruction, the origin of the question, so like this case scenario is from where in all the topics that we have been treating under business law. So is it from where? Okay, or is from where? All right, and then you now have to state the principle. Okay, before you now say that you want to give any advice. So it must follow three stages, as I've said. So, and when you look at this case very well, you will know that this very question is from somewhere. Of course, the secretary is employed by a particular company, but the fact is that he's not representing the company well. So, and this has to do with liability. So this question is actually rooted in a liability that is between employer and employee. So, and that is under we can easily bring it out under vicarious liability, and vicarious liability is under tort. So you can then, if we are to answer this question now, you now say that this case relates to vicarious liability. So you now explain the principle of vicarious liability. The vicarious liability means that where a servant is with the master, whatever the servant does, the master will be vicariously liable. Okay, that is, you now bring out the principle. Then you now advise. So who is to be liable? Okay, the company that hired the car, should the company sue the secretary or the company? So you now give your own advice, but you must be able to state the three stages where the question originates from, and also the principle guiding that very origin, okay, or the position of the law, and then you now give your own advice. Now, the second aspect of it is still under C. Say, assuming that the board of directors of ADEPUSC intend to remove the secretary, the company secretary, say three matters which the notice of removal must contain. And so, and it says state. So we have this one says state. All you need to do is to state and nothing more. Let's go to D aspect. Say by section 401 of CAMA, the legal way to terminate the life of a company is by winding up. So look at the require set ways by which company may be wound up. It says state. So we have this one is a very straightforward question and very easy. State, just state. Okay. Say 3 ways by which company may be wound up. So it's very straightforward, as I've said. So all you need to do is to state. So where a company is to be wound up, either so we have different type of winding up, or a process of winding up of a company, whether compulsory winding up, voluntary winding up, or winding up subject to supervision of the court. So let's look at question number 4. This one has to do with another case. It's now saying advice. So when you read the question very well, it's saying advice. And when it has to do with advice, as I said before, you follow the three steps before you. The first step, the origin. The second, what the position of the law or the principle guiding the other very origin. Then you now give your own, and don't just hurry to give advice. So, but state the origin, so that, and the principle guiding the origin, so that the examiner will actually know that you understand what you are doing, not just to rush and give advice. Question we are still under question 4. The B aspect say an accountant may be an expert witness in computer fraud case. Require state 2 matter in which an accountant must satisfy the court in such a case. Say state. So we have, where you mention state, as I've said, you only have to state, and there is no need for any explanation. State 2 matter. So that can state 2 matter in which an accountant must satisfy. So what an accountant must satisfy before it can be a witness. So an expert witness in a fraud case. Then C aspect say state 5 court of coordinate jurisdiction. 5 court of coordinate jurisdiction mention. All you need to do also is just to state, so it won't take much time. Court of coordinate jurisdiction means court of equal status. Coordinate jurisdiction. So we have so many courts in Nigeria that are court of coordinate jurisdiction, starting from the federal court to Sharia court of appeal. They are court of coordinate jurisdiction. So you just have to state, and when you state, no need of explanation. So you go to the next question. Let's have this question 5. It said a bill of exchange must conform with the requirement of the law. That is the Bill of Exchange Act 1990 before it could be valid. Of course, say comment on the validity of the following Bill of Exchange. Say comment on all this. So that means that in all this, that from this question 5, Roman figure 1 to 3, we have different issues there now. So we have to comment whether it is a valid or not. You say, please pay the sum of, mention the amount, pay this. So what you have to do is that differentiate between this, whether 1, 2, 3 satisfy the requirement of a bill of exchange. That is what the question is talking about. Is it a valid bill of exchange? Is it an inquiry bill? Okay, so whether it is a valid bill, that means that is it a complete bill? Is it a qualified bill? Is it an inquiry bill? So that is what you have to state there. So you read, if you have gone through the video lecture, then you'll be able to answer this very question, to know the type of bill. Okay, whether it is, as I've said, inquiry bill, maybe qualify or any. So when you have gone through, I think you have gone through that, or you have gone through that, you should be able to answer this. Then also let's look at the B aspect. We are still in question 5. It says an unpaid seller under contract of sale of goods has two classes of right, namely right against the goods and right against the buyer. Yes, that is true. Look at the question. State three rights of an unpaid seller under over the goods. So that means in a sales of goods, we have what we call that is sales of goods contract. We have what we call remedy available to the seller. Okay, I think he's talking about seller. Seller here, it should be seller. Let's go back again. An unpaid seller, yes, okay. He's talking about an unpaid seller. So he's having an unpaid seller is having rights over the goods, and also is having rights over the buyer, or right against the buyer. That means that he's empowered to deal with the buyer, because the seller is an unpaid seller, and also is in a position, is having a right to deal with the goods because it's not yet paid. It says state three rights of an unpaid seller over the goods. So this one has to do over the goods. So you have to state it. So that means that the power the seller is having over the goods. And if I'm to help you to mention, we have a right, is having the right as an unpaid seller, right, especially where the buyer fails to pay. That's unpaid. That's what we mean by unpaid, where the seller is not being paid. So that means that the buyer has not paid. So the seller is having the right to retain the goods. That's right of lien. He's having the right of stoppage in transit. He's also having the right to resell the goods. These are the rights over the goods. It's quite different from the right he's having over the buyer. The right he's having over the buyer is to either to sue or to demand for his money. So I'm not going into that anyway. Let's look at C. It says, as a general rule, all persons of all age may sue or be sued in tort require state for exception to the above mentioned general rule. Okay, so state, so the exception. Who are the people? That's why it says as a general rule, all persons. So who are the people exempted? Who are the people you cannot sue under tort? So that is, so state the caliber, state the exception, and the type of people. So that's what the question is talking about. Look at the aspect. They say James, a Nigerian who is resident in US, intend to transfer a sum of $100,000 to Nigeria for investment. Advise James, that is required. Advise James on the step to be taken to avoid breaching the provision of the Money Laundering Prohibition Act of 2011. So is in your position. This one has to do with advice. And before you can answer this, then you must have gone through money laundering. So when you look at what money laundering is all about, if you have gone through it, then you'll be able to answer this question. All right, I would like to welcome this class. I would like to mention welcome us na Magaji. Okay, us na Magaji. You are welcome. You are welcome. So this is an opportunity for everyone hearing me to be able to, understand some certain issues about answering examination question. So you are welcome, Magaji. All right, let's look at question number 6. You say, that it says, the beneficiary under a trust have certain rights in a situation where the trustee does not administer the trust diligently. Requires state for rights of a beneficiary against abuse of power of a trustee. State for right of a beneficiary. This one also has to do with state. Okay, all you need to do is to mention. the right the beneficiary is having, where a trustee is not managing the trust property very well. So the beneficiary is having certain right, okay, over the trustee. So you are only asked to state 4 rights, state 4 of his right, and his right has to do with this over the trust property and also against the trustee. So you mention whichever one you can remember, over the trust properties and over or against the trustee who is not managing the property very well. B aspect say one of the ways to which a contract of employment could be terminated is by dismissal of the employee. Required differentiate between dismissal and interdiction. Of course, there is a difference between dismissal and interdiction. So you have to differentiate between the two, dismissal and interdiction. So we have difference. What I can tell you here is that dismissal is where an employee is asked to leave, is dismissed. Interdiction is just a kind of period of investigation before any step will be taken against the employee, whether to retain him or to send him away. The second aspect says state 3 reason for the dismissal of an employee. So what will I make an employee to be dismissed? So say state. So all you need to do is to state. Okay. Now let's look at C aspect. It said the owner of goods in a contract of hire purchase has some right against a third party who has acquired no good title to the goods under the agreement. State 3 right of the owner against a third party that has acquired no good title to the goods under the hire purchase contract. So it's same as state 3 right. Mention this right. So let us look at this very question on 2017 November. So the same the period given for this question is 3 hours 15 minutes, and that will also include 15 minutes of reading time. So it's a period given to you to read all the questions so that you'll be able to answer whichever one you want to answer. Now we have section A is having about 2 questions. That's multiple choice questions. So you have to read and you pick the one that is the answer. So that's why it says write only the alphabet, either A to E, okay, that corresponds to the correct option in each of the following questions or statements. So if it is A, you write A. If it is B, you write B. So that is what this is talking about. If you look at the first question, for example, here, let me just, before we go to the section B, which so I will say I want to use time to deal with. It says state the law under the law of contract, which of the following circumstances will frustrate a contract. So if frustrate a contract, I mean that which of the following will make a contract not to be enforceable. Okay, so that's just what we're talking about. So we have a performance of the contract, destruction of the subject matter, breach of condition, agreement of the party, mistake by the party. So whichever one that you know that is very close. So sometimes you may have alternative that almost look alike, but you look for the one that fit the question better. So that is what I want to say here. So like, take for example, I want to use this number 1 as an example. Performance of the contract. You look at the question, under the law of contract, which of the following circumstances will frustrate a contract? performance of the contract, destruction of the subject matter. It's saying frustrate, okay? Then breach of condition, agreement of the parties, mistake by the parties. So when you look at it very well, in all these, especially, let us look at B, C, E. So they are almost the same thing. Okay, to frustrate a contract. But out of these three, B, D, E, out of these three, you can actually pick the one that can actually, is at the forefront of frustrating a contract. So I just want to use it as an example, and that is where you have a destruction of the subject matter. If you really understand what I mean by frustration, so there are something that will happen. That's what I mean by frustration, that will not make parties to a contract to continue with what they have promised to do, and especially where the subject matter is destroyed. That is what you call frustration. So I just want to use that as an example. All right, the section B. The section B here is you have about 6 questions, and you have to answer 4. The first question is a case scenario question, which we have to read, and after reading, then you give your solution. You say Bola proposed the sale of an acre of industrial land in Lagos metropolis for 10 million to Ayo, and both agree to the price. The payment to be made within 3 weeks, subject to written offer from Bola. Bola immediately instructed his secretary to prepare and forward the offer, document to Ayo. The secretary, that is by mistake, erroneously type 1 million in the offer as the offer price, which Ayo immediately accepted. Bola refused to sell the land at 1 million naira, claiming that the amount on the offer letter was a typo. It was an error or was a mistake. And Ayo decided to sue Bola for specific performance. When you look at this very case very well, you will discover that it has to do with an issue, based on what I've said before, a particular issue that when you want to answer it, let's first look at what the question is saying before we go. It say advise Ayo on the legal issue involved. Now you have to, before you give your advice, you have to state the position. Like this very case scenario relates to something. So it has to relate with mistake, and that mistake is what we call unilateral mistake. So if you want to answer this question, the first thing you need to say, read the question very well. You have to read the case scenario very well. And now, if you want to start, you have to say that this very issue relates to unilateral mistake. And what is the principle of unilateral mistake? That's the second thing you have to say. The principle of unilateral mistake, the principle guiding unilateral mistake is that court will not enforce a contract where any of the parties to that very contract makes a mistake. One of the parties is the one making the mistake. So the other party is not making mistake. but want to rely or want to benefit from the mistake of the first party. So that is what we call unilateral mistake. Under principle of mistake, we have common mistake, mutual mistake, and at the same time we have unilateral mistake. A unilateral mistake is where one of the parties to a contract is the one making mistake. The other party, the second party, is not making mistake. Okay, so but it's not trying to benefit from the mistake of the first party. So that's what happened in that place. So where there is an error in the process of typing, based on what you have heard about the story scenario right now, and the something is a particular million, and the party, one of the party, mistakenly write down 1 million. So the other party now want to rely on that to benefit from that very mistake. So unilateral mistake. So that is second stage. So you now give an advice on your own advice. So what can you see? So generally, one thing I want to say is that where there is a mistake in the issue of contract, so where court discovered that there is a mistake, court will not enforce that contract. That is the general principle. Okay, so it is not left for you to not give advice, but you must take these 3 steps. The case relates to unilateral mistake. An unilateral mistake is a situation where one of the parties to a contract is the one making mistake. The other party is not, the second party is not making any mistake, but want to benefit from the mistake of the first party. So the second aspect here, the question we are still under A, is a state 3 vitiating elements of a contract. What do you mean by vitiating element of a contract is that what are the things that a contract will be involved, okay, or that will be connected to a contract that will make that contract not to be enforced. That is vitiating element of a contract. Question number B. Under the doctrine of equity, certain general principles of application are observed. Require state 5 maximum of equity. You just have to state maximum of equity here. We have so many maximum of equity, and maximum means that what means future or way that we use to express what equity stands for. That is what we call maximum of equity. So what equity stands for, or the reason why equity was introduced by the Court of Chancery. So that is what we mean by maximum of equity, and that's why we have so many maxim. Okay, equity follows the law. It will come to equity must come with clean hands, and so many others. Let's look at C aspect. In administration of estates and trusts, representatives are appointed to manage the estate of the deceased. Required, explain briefly letter of administration and a will. So explain, this one has to do, you explain what you mean by letter of administration, and also you explain what you mean by will. So you have to explain very well. Not so much, you don't write this thing, it must not be too much, very short, but let your explanation be well stated. Okay, well stated, very clear and unambiguous. So both in explaining letter of administration and will, say explain briefly. That's why the word briefly is actually written there. Let's also look at number 2. In the law of agency, there are obligations the principal and his agent must perform. Require, say 3 duties of agent or his principal. That means that duty of agent. So you're just talking about implied duty of agent, of an agent. So you say state. So you just have to mention Then let's look at the H aspect. It says two friends, Shidi and Musa, are equal partners in a general partnership engaged in buying and selling of vehicle tires. Chidi borrowed 5 million from a finance house to purchase tire stock for the firm, which were kept for sale in the firm's warehouse. Musa, on behalf of the firm, also obtained a loan of 2 million from a bank to buy imported shoes, which were displayed for sale inside the firm's warehouse. The firm's warehouse was razed by fire, and all the goods inside were lost. This made a repayment of both loan impossible. All right. So the finance house and the bank separately intended to sue the firm to recover the loan granted to the partners. So let us look at the requirements. So this is where we are going to say, explain the legal issue in the partners transaction. Then the second aspect say, advise the finance house and the bank accordingly. So let us now explain the legal issue here. So we have so many legal issues here, because when we look at it very well, we discover a kind of what the firm is to do. The two people, we have two people there. When you read it very well, that's why before you attend this type of person, you read again the first time, the second time, or the third time. You read again, you begin to analyze those points. So when you look at it very well, okay, let's go back. So that let me use this to explain. You see, there are two friends, Shidi and Musa. You say are equal partners. Are equal partners. That means that the general partners. Okay, engage in buying and selling of vehicle tires. That is their work. Buying and selling of vehicles tires. Okay, that is what the firm is doing. That's what they are involved into. Shidi borrowed. That's one of the partners. 5 million from a finance house to purchase tire stocks for the firm, which were kept for sale in the firm's warehouse. So what she did was in accordance with what the firm is doing or registered to do. Whereas on the side of the other person, Musa, on behalf of the firm, also obtained a loan of 2 million from a bank to buy imported shoes. So when you look at this, what she did was in accordance to the purpose of the business of the firm. What Musa did was contrary to the business of the firm. Those are the legal issues. So that means that in this case, Musa has gone outside, what the firm is registered to do or is said to be doing, or the business of the firm is outside the business. And generally, in partnership, a partner can only buy or do anything whatsoever for the firm it belongs, what is actually part of the firm business. When a partners go ahead to do any other thing outside the firm business, or any other thing that is not connected to the firm business, that means that partner is on his own. So I'm just only using this to explain to you. That's when the question says, explain the legal issue in the partner's transaction. So the transaction was okay, but Musa transaction was not okay. He now say, advise the finance house and the bank accordingly. So what will you now give to the bank? What type of advice will you give to the bank and the finance house? So that is left for you. Let's look at C. In the Banking Act, the banker and a customer have rights that may be exercised in the relationship. Require state 5 rights of a bank to the in the relationship. So rights of a bank in the relationship. So it's only saying that one should, 5 rights of a bank in the relationship. Rights of a bank. So that means that what this question is actually referring to has to do with what bank is expected to enjoy. Yes, state 5 rights of a bank in the relationship. So what the bank is to enjoy from his customer. So that, in a nutshell, what it's trying to say is that what are the duties of customer to banker? So that is the straight as question, the duties of customer to a banker. Question number 3. Under the criminal code, there are various offenses that are fraud related. You are required to explain the following: bribery and forgery. So all you need to do, if you have gone through the video lecture and in the video lecture there is a place where we'll explain criminal law. So we have bribery, we have forgery. So you can go through that, or you have gone through that, you'll be able to answer this question. So the B aspect says contract of employment is a voluntary agreement between employer and employee. A distinguish between termination of employment and summary dismissal. Distinguish, differentiate. So termination of employment and summary dismissal is quite different. Summary dismissal, so you try to explain briefly the difference. Okay, not much, but they are different. So summary termination means to end the service, to put an end the service of an employee. Okay, so summary dismissal is where you tell a worker to stop. You are also, it's the same thing. It's the same thing. Meaning that you are telling the employees to stop work. Okay, but what makes the difference is the procedure. Summary dismissal is where you tell an employee to stop working now, immediately. Summary dismissal. But termination may not be summary dismissal. Every summary dismissal is termination, but not every termination is summary dismissal. Termination may involve a process of time. That's when an employer give an employee sometimes, okay, maybe 1 month notice to go. 2 months notice is part of a termination. Termination means that the process of the law must be followed. That is in the agreement between the employer and the employee. What is stated there, whether it is 1 month notice or 3 month notice, it must be followed. That's termination. It says states 4 duties of employer to the employee. That is second question. Duty. So state just mentioned. Then let's look at the C. At common law, a company has implied power to borrow money through issue of debenture to the public. Require. Explain briefly the following: floating charge and 2 advantages of floating charge. Explain briefly. So where you see the word explain briefly, it also means explain, make your explanation to be short. So that is explain briefly. So you just have to explain, and then you move to the next question you want to answer. Let's also look at this case scenario. Fresh Food PSC recently held an annual general meeting where it declared a net profit of 2 million for the year. The board of directors did not recommend payment of dividend in the agenda and notice of meeting, but okay, canvas a plot back of the profits to reduce the 20 million trading issue accumulated accumulated over the past 10 years. Shareholder at the AGM, however, unanimously passed a resolution approving dividend payment for from the year's 2 million profit, basing their decision on the fact that they had not received any return on their investments in the past 10 years. The directors refused to pay the dividends, and the shareholder have threatened to remove the directors from office at the proposed extraordinary general meeting to be reconvened soon. Explain the issue involved. So we have issue involved in this. Based on the position of the law, dividend is a privilege, it's not a right. So if we are to explain that, so that's why I say like this, you have to read again and read again and read again to understand what the scenario is all about. So, of course, the board of directors, they have the right to declare dividend. It is the board of directors that is having the right to declare dividend. So, that a company makes profit does not mean that board of directors will declare dividend. They can declare profit, but they may decide not to give shareholder anything, especially if there are debts to be settled. They may decide to use the profit to settle the debt of the company. So it's not necessary that they must declare dividend for shareholders to benefit. So that is the position of the law. So, and also, it's not the work of members, shareholder, to declare dividend. No, it is the board of directors that will do that. So even sometimes where the board of directors declare dividend, the shareholder cannot increase the dividend. So they are only allowed to reduce it, but not to increase it. The dividend declared. But where directors don't declare, there is nothing they can do anyway. So that is the position of the law. And the second aspect say, advise the director on shareholders and shareholder as appropriate. So you have to advise them. The companies another matter as I'm treating B as B now under question 4. The Company and Allied Matters Act, Law of the Federation of Nigeria 2004 as amended, provide that directors of every public company shall prepare annual financial report for each year of trading operation required. Take 6 individual report that will be contained in the public company's financial statement. So you see state. So it means you have to mention the report. So we have so many reports that made up a financial statement. So you mention the report. And also thought the C aspect, thought are classified into different categories. Require state 4 categories of thought. Let's look at question number 5. A. The judicial system has hierarchy of court. Require. Explain briefly the meaning of court of coordinate jurisdiction. So there was a time I said this, that court of coordinate jurisdiction means court of equal status. Court of equal status. And the second aspect says state 3 examples of court of coordinate jurisdiction. 3 examples. So we have so many examples, more than 3, of court of equal status in Nigeria, starting from federal court to the Sharia court of appeal or customary court of appeal. Then the B aspect, say the Constitution of the Federal Republic of Nigeria distinct. Okay, the Constitution of the Federal Republic of Nigeria has distinct characteristics. Require state 5 of the characteristic. Characteristic of Nigerian Constitution. So mention the characteristic, that is the feature of Nigerian Constitution. Nigerian Constitution, of course, is written and also is rigid, means it is very hard to amend. It's written, is contained in a document, and also is federal, right? So let's go to another question. There are various fraud-related offenses under criminal code. You say require explain briefly false pretense. Then secondly, second aspect say state 2 factors that are immaterial to the defendant plea in a charge of false pretense. So in all these questions, you are asked to explain briefly false pretense. Then after that, you now mention the 2 points in this second aspect. That one is just mentioned, that is state, you mention it. Then let's look at D. The Money Laundering Act, Law of the Federation of Nigeria 2004, as amended, imposed stiff penalty on person who convert or transfer resources or property derived directly or indirectly from illicit traffic in narcotic drug. Require explain briefly penalty for each offenses committed by the following: 1, an individual, and 2, a body corporate. So where you have a body corporate and you have an individual, okay, and where in the constitution or in the law, the punishment of an individual is quite different from where it is a corporate body. Most of the time, corporate body will be asked to, pay a kind of fine. Why it is an individual, sometimes it may be fines, sometimes it may be also an imprisonment. Question number 6. Let's look at this. It says in January 2016, Bayo entered into a hire purchase contract with Shehu, the owner of a limousine, for 3 million naira, payable over 6 equal monthly installments. Commencing February 2016, Bayo paid 4-month equal installment on the date, but stopped further payment thereafter. Bayo sold the car to Shike in August 2016, and armed robbers snatched it from Shike in September 2016. It was recovered by police in October 2016. Both Shehu and Shike appear at the police station to claim the car required, state the legal issue involved, and advise Shehu and Shike accordingly. So when you look at this, you have to also to read it well to be able to state the legal issue involved. So we have some legal issue involved. It has to do with under hire purchase. What is the right of the hirer? What is the right of the owner? What is the right of a third party? So under hire purchase, we have so many issues involved. Hire purchase and also sale of goods. So so state the legal issue. So when you understand hire purchase very well, you'll be able to state the legal issue here. Who is a party that is making mistake? Who is a party that is not making mistake? And you'll be able to give advice. A contract, B aspect. A contract of sale and hire purchase respectively resemble each other. Require distinguish between contract of sale and that of hire purchase. Okay, so these two contracts are quite different. So that is why we need to distinguish that. The question is distinguish between them. So you have to give the difference. What makes them to be different? Question C aspect. Terrorism is an offense. Require in Nigeria. Require. Explain briefly two acts classified as terrorism offenses and the applicable penalty. So you mentioned the offenses and also you mentioned the penalty. The Evidence Act 2011 provide that electronic evidence is admissible in the prosecution of computer fraud. Require state 4 ways to authenticate email messages. State 4 ways to authenticate email messages. So what that question, the question is state. So it must be stated. Now this is May 2017. We have these questions, multiple choice questions, and also we have other questions that is in the section B. Let us look at this number 1. I want to use it as a kind of example. You say, which of the following is not the source of Nigerian law? A, treaty. B, common law. C, status of general application. D, status of limited application. B, Nigerian status. You say, which of the following is not the source of Nigerian law? So all this is not. So that's why there was a time I was trying to say that you need to look at it where you say, which of the following is not. So the people involved want you to take notice of not. That is why it is written in capital letter, not. And you can see that the answer to this treaty, common law, status of general application, Nigerian status of limited application. There is nothing like status of limited application. So what we can pick now is, let us pick the status of limited application. That should be the answer. So I want you to look at also the section B. We also have all this, and if you are to answer the questions, or if you are to look at all these questions we are looking at now, so I advise you to look at the past questions Okay, the one I've tried to explain, not that I've really answered even the answers, but I'm just trying to guide you on how to answer those questions. So you can use what I have said even to answer all these ones here. The one I've not even answered, okay, and also the one, any other question that you may likely come across. So we have this process, and so you need to understand this process very well, and that is why whenever you are answering any question, as I've said, you really need to understand some point what business law is actually about, or let me put it this way, the area where a student needs to be careful about business law, let me say it again, is understanding. Okay, understanding, especially where a case is being analyzed or where a story of a particular thing is being mentioned. You have to read it very well and read it before you begin to write. As I've said, ensure that you don't be in a hurry to write anything where it has to do with a case being brought out for you to advise or to state the position of the law. So don't be in a hurry, read very well before you answer. When you look at this section B, you talk about, look at the question 1. Court of record are classified as superior and inferior court. State 3 superior court of record. Now, when you look at it, the other year also, the one of 2017 November, we also have almost something like this there. Why is this question coming this way? Maybe it's because sometimes students don't answer the question well, so then that question will be repeated. Now we have what we call court of record. Nearly courts in Nigeria are all court of record, but most of the time when we refer to court of record, we are talking about superior court, and then superior court starts from state high court, federal let's even say from the apex court, Supreme Court, Court of Appeal, Federal High Court, State High Court, Sharia Court of Appeal, Customary Court of Appeal, we have National Industrial Court, and so those are court of record. So court of record, we have court of record. So most of the courts, as I've said earlier on, Nigeria are court of record. So, and they are in superior court. B as per se, case law is also known as judicial precedent. Requires state for advantage of case law. So case law is having a lot of advantage, and that is what the another way you can ask this question, or you should have asked this question, is the advantages of judicial precedent. So we have a lot of advantage in judicial precedent. So it says state for advantages of case law or of judicial precedent. Let us look at C aspect. Adigwe and 30 of his friends form an association named Adig 30 Partners in 2015. Last week, all the friends met and decided to register Adig 30's partner under the business name provision of the Company and Allied Matters Act. To what effect? To that effect, they have approached you for legal advice. Require advice Adigwe and his friend on the legality of their proposal. For a person to be able to answer this, you need to understand what it means by partnership, number of people that can form partnership, okay, number of people that can form a business name, number of people that can form a company. So when you are able to understand all this, and you'll be able to understand and answer this question well. Then the B aspect says state types of business that could fit the proposal of Adigui and his friend. So you also, this one is in form of a advice. So it depends on how the question look like. So especially where a case like this, where a situation like this is being brought out. So like this one is talking about an issue. There is a problem in the issue and you are asked to give advice. So, and for answer this question, one really needs to understand what the topic, where the question came up from, is talking about. Let's look again. Let's look at D aspect. State 5 reasons for which the Corporate Affairs Commission may refuse to register the document of proposed company. Of course, CAC may decide not to register a company for any reason whatsoever. Okay, but those reasons were for some certain reason mentioned, yes, in comma. So if the reasons if a company, a document, a proposed company, okay, document is submitted, so CAC may decide not to register the company, okay, if there is a reason as being mentioned in comma. So if the company is involved, or so if the reason why the CAC will not register the company is because it is part of what is written in comma, so CAC will not register the company. So I believe with what I've said, you should be able to go through all other questions here. And also I would like to tell the class, if you are hearing me, I want to tell you now that if also you want to ask any question on any of the topic under business law, please, you are free to ask. Please ask and I will answer. So any question at all. So you still have some days before the examination. Please, if there is any question at all you want to ask me, okay, sorry, any question at all you want to ask, please ask me and I will give you the answer. So on any topic under this business law. So ensure that if you have not maybe you have not completed going through the video lecture, ensure that you go through the video lecture. Ensure that you go through all the topics. There is no how you go through all the topics. Listen to the topic very well. Jot down point. So as you are listening to the video lecture, you jot that point. There is no how you will do that well and you will not pass this examination. Definitely you will pass and pass successfully. So ensure that you get the video lecture that you go through. You can go through. If you still have any topic that you have not covered, you still have time to go through all the topics and ensure that you cover all the topics. So prepare very well for this examination. So there are some things are necessary, okay, which you must do. Some things are not necessary. Okay, focus. What you need to do most now is for you to focus on solving past questions. And that is what we are trying to do here now. In this way, what we are doing now, to solve past questions. So that you'll be able, when you look at past questions and you also look at the solution, you'll be able to know what the examiner wants you to do. They may ask a particular question, so you may know how to answer, but how do you answer? That's actually very important. So in solving past questions, you'll be able to know the type of questions the examiner used to bring out under each topic, and also how to answer those questions is quite very important. So understand that, and I wish you the best in this examination. So please, I'm saying it again, if you have any question to ask me, So please do that. If you still have time, you can post any question to me anytime of the day. So when I see it, I will give you an answer. So do that. Let our communication continue. I wish you the best, and I pray that we have the best. God help you to pass this exam.